Good afternoon, everyone. I call this meeting to order. Welcome to meeting number 119 of the House of Commons Standing Committee on Canadian Heritage. I would like to acknowledge that this meeting is taking place on the unceded traditional territory of the Algonquin and Anishinaabe people. Pursuant to the order of reference of Wednesday, November 22nd, 2023, the committee is resuming its consideration of Bill C-316, an act to amend the Canadian Heritage Act.
I'm going to give you some quick housekeeping, guys, because I just want to remind you again about the new rules we have. And so I want to remind members and other meeting participants of the following preventative measures to protect the hearing of the interpreters. So, to prevent disruptive and potentially harmful audio feedback incidents that can cause injuries, all in-person participants are reminded to keep their earpieces away from the microphone at all times. And when you're not using it, there's a decal on the desk right in front of you with a picture of an earpiece. Please put your earpiece face down on top of that when you're not using your earpiece. Keep your cell phones away from the microphones, etc., because that causes the feedback. Now, and I want to read it again because I'm asked to do so. In the communique from the Speaker to all members on Monday, April the 29th, the following measures have been taken to help prevent audio feedback. All earpieces have been replaced by a new model that reduces the probability of audio feedback. The new earpieces are black in color, and the old earpieces were gray. Please only use a black approved earpiece. By default, all unused earpieces will be unplugged at the start of a meeting. When you're not using your earpiece, place it face down on the decal on the right-hand side of your table, and with the middle of the sticker, and you must make sure that the earpiece is facing downwards. Consult the cards on the table. There are some cards here to help you to understand what the rules are with regard to feedback. And the room layout has been adjusted, as you note, to increase the distance between committee members so that we're not all causing each other audio feedback. Now, I want to thank you for your cooperation. As you well know, today's meeting is being done in a hybrid format, and therefore I just want to remind you that you're not allowed to take a photograph of what's going on in the room because it will already be on a website. You can look at it there. I'm informing the committee that all witnesses have completed the required connection tests in advance of the meeting. Now, I have a couple of general comments for the benefits of members. Please wait until I recognize you by name before speaking. For members in the room, please raise your hand if you wish to speak. And for those in the chat, please press the hand decal there. If you want to get interpretation, there's a little globe at the bottom that you can press for interpretation in English or French, a language of your choice. Now, we have some witnesses who have been here before. So if you notice, we have 5 witnesses. Jeffrey Sigale, who is assistant professor, and he will not be providing an opening remark because he already provided one when he was here earlier on. So we have Josh DeHaas, who is a counsel for the Canadian Constitution Foundation. He will be presented 5 minutes. And we have the Maître Françoise Côté, attorney and doctor of law. He is of the Droit Collectif Québec, and he will be presenting 5 minutes. The other people, Egal Canada with Bennett Jensen, Director of Legal, and the West Coast Legal Education and Action Fund with Jabira Humera, staff lawyer. They will not be providing opening statements. So just we have that clear. We have 2 opening statements. Now, for the people making the statements, you have 5 minutes. I will give you a shout out, literally, when you have 30 seconds to go, so you can wrap up what you're saying. It doesn't matter if you didn't finish everything you wanted to say. When you're being asked questions by the members, you would be able to elaborate on some of the things that you didn't get to say. Then we after that, we have a question and answer round, and when we get to that, I will tell you what we're going to do. So I want to begin with Josh DeHaas, counsel for the Canadian Constitution Foundation. Please, Mr. DeHaas, you have 5 minutes. Begin. Thank you.
Good afternoon, Madam Chair. My name is Josh DeHaas. I'm counsel with the Canadian Constitution Foundation. The CCF is a nonpartisan legal charity dedicated to defending Canadians' rights and freedoms through education, communications, and litigation. The CCF is funded by individual donors across Canada who support our view of a freer and fairer Canada. One might think the CCF would be first in line to defend a program that hands out millions of dollars per year to fund litigation on constitutional and quasi-constitutional issues. After all, it's easier to apply for thousands of dollars of taxpayer funding than to build up a litigation fund $50 or $100 at a time. But the CCF doesn't support the court challenges program, and it should not be entrenched into law. We don't support the Court Challenges program for 3 reasons. First, the Court Challenges program takes the debate about the meaning and content of rights out of Parliament and legislatures where the debate more often belongs. Second, the Court Challenges program risks warping the Constitution through the ideological biases of the minister in charge of the program and those who decide which particular cases get funded. Third, there are better ways to strengthen constitutional rights and freedoms than by appointing a small group of elite law professors to divert tax dollars to their preferred legal challenges. Allow me to elaborate on my first point that the Court Challenges program removes the debate about the meaning and content of rights from the proper venue. The Court Challenges program encourages citizens to push for their preferred social policies through the courts rather than by convincing their fellow Canadians. One example of this is the medical assistance in dying case, Carter in Canada. In Carter, the applicant had an irremediable medical condition that made it physically impossible for her to end her own life and therefore stop her own suffering. The courts were well placed to decide whether the state prohibition on MAID violated Ms. Carter's rights. However, interveners used that case to push for recognition of a broader right to euthanasia, which led to a rushed implementation of a MAID law that didn't properly take into account many stakeholder concerns. Parliament was much better placed to decide this difficult policy question than the courts. MPs are democratically accountable, which forces them to consider a wide range of viewpoints. Parliament also has structures in place in its lawmaking, such as debate and committee hearings, such as this one. Courts, by contrast, are limited by the evidence and the facts that are before them and ill-equipped to take on this type of social policy making, yet that's what the Court Challenges program tends to encourage. Which brings me to my second point, that the Court Challenges program risks warping the Constitution through ideological biases. The Court Challenges program is administered by a management committee that consists mostly of academics and administrators from the University of Ottawa. Despite the Court Challenges program making decisions about which lawsuits are of such national importance that they ought to be funded by all Canadian taxpayers, the program is overseen by a small group of academics and administrators working inside the Ottawa bubble. The 7 expert panelists who make the case-by-case funding decisions are also drawn from an elite group of legal academics and human rights experts who don't represent the breadth of Canadian viewpoints on the law or which issues are of national importance. The current panel, for example, consists of several legal progressives, but no apparent legal conservatives. And that means a tiny clique of left-leaning academics is giving out millions of taxpayer dollars each year to decide which proposed constitutional challenges are more likely to be heard. And the ministers who have overseen the program in recent years appear to have appointed mostly people who share their viewpoint on the Constitution and are more likely to fund cases that are more likely to push the constitutional jurisprudence in the direction they want it to go. The same risk exists with a future Conservative government whose ministers might be tempted to appoint only legal conservatives, thereby warping the jurisprudence in a different direction. The only way to avoid this sort of political bias is to abolish the program entirely. Which brings me to my third and final point, that there are better ways to ensure the Constitution is respected. First, politicians could ensure that judges are appointed in a timely manner so that those facing potential violations of their rights can have their cases heard in a timely fashion. Second, politicians could be braver about defending rights and freedoms by proposing rights-protecting legislation by speaking out when other politicians propose rights-infringing laws, or by intervening in cases. Third, and most importantly, rather than taking millions of dollars each year out of the pockets of Canadians so that an elite group of legal experts can direct those funds to their preferred legal challenges, parliamentarians can ensure that rights are respected.
Please wind up, Mr.
Canadians,
DeHaas. Thank you. You can wind up. Finish your sentence.
By letting Canadians keep more of their hard-earned money so that they can direct it to civil society groups like the CCF that are fighting for their rights and freedoms. Thank you.
I now go to Droit Collectif, Quebec. Mr. Francois Cote, attorney and doctor of law. Please, you have 5 minutes, Mr. Cote.
You are muted.
Mr. Cote? Oh. You are muted. Press your button to unmute. What's wrong? No. He cannot hear? He cannot hear us.
No. So we'll just double check.
We will just suspend for a second while we check what's going on here. Mr. Cote, you have 5 minutes, please. Begin.
Merci, Madame la Présidente.
Thank you, Madam Chair. Can everybody hear me? Perfect. Thank you, Madam Chair.
recognize and salute the previous intervention by my colleague, Mr. Dihas, which was very enlightening. That said, Madame la Présidente,
Madam Chair, members of Parliament, distinguished members of this honorable committee, it's a privilege for Droit Collective Quebec to appear before you to share with the Standing Committee on Canadian Heritage our observations and recommendations concerning Bill C-316. Droit Collective Quebec is an independent civil society organization whose mission is to contribute to the defense of collective rights in Quebec, particularly with regard to the linguistic and constitutional rights of citizens. Based on a non-partisan approach, the organization's work covers many fields of intervention, including popular education, social engagement, political representation, and in particular legal action. To this end, we are frequently called upon to intervene before the court to participate judicially in the defense of such fundamental rights for and on behalf of Quebec citizens. So it's with field knowledge and experience that we are appearing before you to testify about the reality we know well. More clearly, we interact directly with the Court Challenges Program and its grant application process. So we are coming before you with direct, on-the-ground knowledge of the subject matter of the bill before this committee. Justice is blind, but alas, it's not free. What is a constitutional guarantee worth to the citizen who sees it flouted or who may have to pay hundreds of thousands of dollars in lawyer's fee and legal expenses that he simply doesn't have? The federal government in 1978 created the Court Challenges Program, a neutral and independent federal grant program designed to financially support Canadian citizens in asserting certain constitutional rights, language and human rights before the courts. Over the years, the CJP has taken many forms, but since its inception has always remained a granting program controlled by the executive branch of government. And this has always ensured, it has always adapted to the fluctuating demands of the changing economy. That has made it more vulnerable to political winds. The program has been abolished, re-established, re-abolished, and re-established since the 1990s. Since inception, its scope and indeed its very existence has been solely dependent on executive power and therefore on the political will of the government in power. People don't want it to be dependent on political wills. Droit Collective Quebec approves Bill C-316 for the legislative codification initiative it represents, but believes it still needs improvement on two major aspects. First of all, Droit Collective Quebec applauds the initiative to codify into law such a program that could lead to lots of challenges with its significant social and legal ramifications. But out of transparency, Bill C-316 concludes that its goal of holding the government to account shouldn't this logically apply to the administration of the funds of the Court Challenges Program? Let's not lose sight of this. A constitutional challenge may result in a judicial declaration of invalidity of a democratically adopted law. We're talking about the use of public funds to change the laws of a state. There is public interest involved. We need to find out what is done with this money and what is being funded. But at present, the CCP provides no details on the distribution of its budget. $3 million a year to fund dozens of constitutional challenges, but no public information is available to indicate to which causes, for which cases, and these funds are dispersed. Of course, we need to respect the confidentiality of the parties involved. But we are not violating the confidentiality of any party when we indicate the cases. We could simply say, in the case A versus B, engaging constitutional rights 1, 2, and 3 before the Superior Court of District X, and so on. The revelation of this information will be entirely justified by the public interest. Ultimately, however, given the important political consequences, we feel that it should be amended.
Merci, Madame la Présidente.
Thank you, Madam Chair. We believe that at least the cases being funded should be indicated. The CCP should not in any way help to fund challenges of provincial legislation. The CCP should be exclusively limited to laws under the federal government. There's something that is very uncomfortable when we...
Very much. You'll have an expand later on. Thanks. We're now going to the question and answer segment. And I want to thank the witnesses for their presentations, and I want to go to that segment. The first segment is a 6-minute round. The 6-minute is a question and answer. It includes a question and answer. So I'd like everybody to be as succinct as they can, please, so you can get more questions in. And so we begin with the Conservatives, Rachel Thomas. For the Conservatives, Ms. Thomas, you have 6 minutes.
Thank you. My first question here will go to Mr. Diaz. In your opening remarks, you said that the only way to avoid partisanship within the Court Challenges program would be to abolish it altogether. I'm curious if you can expand on that a little bit more as to why there wouldn't be another way that it could perhaps be amended or revised to achieve that end.
Madam Chair, I don't believe that merely amending the program would fix the concerns about bias, because at the end of the day, the people who choose the particular cases that get funded would always be chosen by a minister. And if you did not have a Court Challenges program, instead, you have a situation where individuals choose which particular civil society organizations they wish to support with their own funding. And that's why I believe that that reform is not the way to go.
Thank you. I have a follow-up question then, I guess, with that to Mr. Sigalet, and that is, I'm curious if you would agree or if there might be changes or amendments that you would suggest.
I tend to agree. Look, you have two different rights organizations here, one of whom gets funding from the Court Challenges program, the CCF, and one of which is more radically progressive, the EGAL Canada, that receives probably we know receives funding from the Court Challenges program. We're not sure about that because it's the lack of transparency. That already shows the kind of partisan charge here. I would say that there's an extent to which Mr. DeHaas makes a great point, which is that if Pierre Poilievre wins the next election and Conservatives are in charge of this program and they reorganize it, even if we put in institutional structures that require kind of bipartisan approval for lawsuits to go forward, and there are ways you could model that by requiring there to be a multi-party, every party needs to approve of a lawsuit before it goes forward, some kind of formal rule like that from the committee, or every party gets to nominate one member of the board or something like that. This is never going to fully work, partly because your party is never going to agree to the NDP and the Greens getting to choose somebody, both, and then there being a non-conservative picked majority on that committee, right? There's all kinds of problems you're going to experience this way, and inevitably there's going to be the temptation to rig it your way to fund the kinds of cases that Conservatives care about. And so the problem is that there's just always going to be this back and forth, and the problem also comes in the devil in the details, the difficulty of properly designing an institution that gets bipartisan buy-in. That's just very difficult to organize. Although I'm not saying it's impossible. I'm just saying it's going to be very difficult.
Thank you, Mr. Sigalet. I am curious about one other thing from you, and that is, in your opening remarks from the other day, you commented on the origin of the Court Challenges program. Now, we know that it was originally created by Trudeau Sr. in order to challenge Quebec provincial laws. We know that this, of course, poses risk to federalism in Canada. And so I guess I'm just curious if you can comment on that further as to the impact that this program has with respect to provinces and their jurisdiction.
There's a well-known article in Canadian Political Science by F.L. Morton called the centralizing effects of the Charter on Canadian federalism, which notes that this program is part of kind of centralizing effect where federally appointed judges are deciding rights cases that rights challenges to provincial laws, and the litigation that they see is influenced by the funding for different groups challenging federal funding through this program for different groups challenging federal laws. So it's kind of a sneaky way for the federal government to disallow provincial laws on that and on that analysis. And it's sort of this mini debate in political science about to what extent does that happen, to what extent does it not. Unfortunately, it makes it harder for us political scientists to have that debate properly when we can't tell what the program's funding, right? So one key thing, like I said in my testimony, is whatever you do, make this bill transparent, ensure transparency so we know how much federal funds Mr. Jensen's organization is getting to sue Saskatchewan, let's say. And then that becomes public and more accountable, right?
Yeah, precisely. Thank you. I appreciate your comments. Mr. DeHaas, I have a question for you concerning an article that was written by you in the National Post in 2019 entitled, "Why Are We Paying People to Sue the Government?" In there, you said giving money to lawyers to sue the government is a backdoor way for Liberals to force the policy changes they want without the political risks. Can you expand on that further? Why is that a correct statement?
Certainly. So this program, as I mentioned before, it's the minister who appoints, at the end of the day, the 7 experts for each part of the program who decide which cases get funded. And if they appoint people that all have their own particular view of the Constitution, then it's more likely that they will get they will get the cases before the courts that are more likely to lead to the particular policy outcomes that they prefer, when the way that should work in a democracy is that those particular politicians go to the people and say, this is what we think the law should be, and fight for those particular viewpoints. And we're talking about the program being used as a backdoor way to modify federalism. I think you can think of potential examples where there are provincial laws proposed and the federal government, for political reasons, doesn't want to upset people who support that particular provincial law, but they disagree. And so they just leave it to the court challenges program to bring forward cases that are more likely to shift the jurisprudence in that particular direction.
Thank you very much for your time, gentlemen.
46 seconds, Ms. Thomas, in case you wanted to make a comment or anything. No?
I don't think I do.
Okay, that's good. Thank you. Okay, Patricia, you have 6 minutes.
Thank you, Madam Chair. And Madam Chair, can you just let me know when I have 1 minute left, approximately?
When you have how many minutes left?
1 minute, as I'd like to share the floor with my colleague. So my question will be addressed to Mrs. Humaira Jabir. We have heard statements from some of the witnesses who have hinted to the desire to restrict the use of this program, the CCP, by Quebec's English-speaking minority community. In your view, Mrs. Jabir, what may be the impacts of such a restriction?
Thank you very much. Certainly, I think what's important for us, speaking on behalf of West Coast Leaf, an organization focused on gender equality and substantive equality, which means equal protection of the law and equal benefit of the law for all people. What's important for us is that that really be the case. And in terms of cases that come before the CCP for consideration, that those be considered on the basis of the legal questions that are at issue, the importance of those legal questions to the development of constitutional law, the impact of outcomes not only on one community necessarily, but on a broader range of communities. So I think it's very important that we take the focus out of individual cases and individual contexts, because what this program is also about the development of constitutional law, recognizing that we live in a society in a legal system that is based on precedent. And cases decided by the Supreme Court of Canada that relate to one area have legal implications for people across the country. So I think that's really an important consideration for this committee, that as you consider the cases that the CCP might be looking at, to take it out of individual contexts or individual communities and recognize that constitutional law doesn't develop just in one context, but it develops for everyone. And that's an important aspect of, for instance, the intervenor process that the CCP program funds, which allows in groups that might be impacted by a case to also participate in those legal proceedings to ensure that the wider implications are before the court.
So I thank you for that. So I understand it's clear that you would think that the bill would benefit from strengthening the assurances made for access to all communities. Is that correct?
Absolutely, absolutely. And certainly, I think it's very important that those who are marginalized, who face intersecting forms of discrimination in our society, have access to justice. And that rule of law is premised on access to justice, and our charter rights and human rights depend on that access.
Okay. And in your view, is it appropriate for the program to be limited to just test cases?
It really depends how test case is defined. The CCP program seems to define that in a more broad way at the current moment to consider issues that courts have not necessarily addressed before. But it is also important that the CCP program deal with cases as they come forward. For example, if there is a case that's brought to prevent the rollback of a benefit that is provided by government, as well as cases that deal with novel issues that may not necessarily be a novel legal issue, but may address a legal issue in a novel context. So the test case can be one way of framing that, but it should be interpreted broadly by the program.
Okay. And in your view, how important is the privileged relationship between the program and its grant recipients? And why must we strive to maintain a balance between transparency and this privileged relationship?
The key aspect here, and I stated this in my opening remarks, is that if we go back to the Charter is a negative rights document. It prevents against the infringement of people's rights by government. Litigation related to the Charter, as well as other human rights litigation, is necessarily adversarial, and the government is on the other side. The worst case scenario for anyone who is involved in constitutional litigation or involved in this program would be to see the politicization of funding such that a case that's brought forward that has serious issues, the funding is limited or pulled for a political reason. And that's where the privileged relationship is important. And that's what the committee must focus on, is that transparency must be balanced with independence and the protection of the applicants to the extent that their litigation may not be damaged or interfered with because it isn't in favor of the government, which necessarily it may not be. It may run counter and likely runs counter to government interests. So I think that's the key concern. And on the question of litigation privilege, government has litigation privilege. And it's important for this committee to consider why parties that, because of their need, seek out funding in order to access justice should have to give up their litigation privilege and the equity concerns around that because they access what I would say is not necessarily, it could be a small amount of funding compared to the total cost of litigation that a party might have to encounter in order to bring their claim forward.
I'm sorry, Patricia. I forgot the 1 minute. I was just going to give you a 30-second call. So if you wanted to...
So I see
Rappel au règlement, Madame la Présidente.
Point of order, Madam Chair. Point of order. I believe that out of courtesy, our colleague had asked for a 1 minute warning. I think it would be a courtesy for the committee to grant her the time she had requested so that she can yield time to her colleague.
I can't even hear what you're saying in French, never mind get the translation. For something's wrong with my volume. It keeps going off completely. Sorry, can you begin again? Sorry.
Madame la Présidente, ma collègue Madame Latanzio avait demandé, avant de commencer son tour de parole, à ce que vous l'avisiez. une minute de...
had asked that you give her 1 minute at the end. So it's only courteous for the committee to give her the 1 minute she had requested so that she can give her colleague the time she had requested at the beginning of her statement.
Committee is in favor unanimously. I'm fine with that. Everyone seems to be nodding. Go ahead, Patricia, you have a minute.
Madam Chair, the 1 minute that's left, I will cede it to my colleague.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam Chair. I would like to move a motion proposed by Noor Mohammed last week that was distributed to all members. The motion is as follows. In according to 108, the study should carry out a study of at least 4 meetings to carry out a study on extremism in Canada. This would include the way extremism plays a role in disinformation and misinformation, how to better support preventative measures, and how to better support preventable measures for ideologically motivated extremism in Canada, and the connection between far-right extremism and harassment towards journalists, women, Indigenous peoples, Black and racialized communities, members of the 2S LGBTQ community and religious minorities, that the committee report its findings and recommendations to the House, and that pursuant to Standing Order 109, the committee requests that the government table a comprehensive response to the report.
Thank you. Has everyone had a copy of that motion? I don't think I have either. I've only got a copy of another motion. So I don't know. Clerk, do we have a copy of this motion that was not distributed or that you received?
It was distributed on May 2nd, or it's from May 2nd, but I can print out a copy for the committee if.
Will we suspend while everyone gets a copy of it? Because I don't have a copy of it. Suspend? To the members who are witnesses here is that a motion has been moved and it's going to have to be dealt with right now. So I'm going to ask you to stand by. Maybe we can deal with this motion very quickly. If we see that it's not going to be dealt with quickly, we may have to go to some other conclusions and decide on how to let the meeting move forward. But so we will begin. Ms. Romanado, would you like to speak to your motion?
Thank you, Madam Chair.
Excuse me, Nikki, is your hand up? And is Michael's hand up? All right, so, okay
Yes.
then.
I wanted to
Okay,
make
we
an
put you on the
amendment.
list. Ms. Romanado is speaking to her motion.
Thank you, Madam Chair. Other than to say that I support it, I will cede the floor to the next speaker. Thank you, merci.
Sorry, I was looking at the list lineup. What did you say, Sherry?
I said, other than that I support it, I will cede my time to the next speaker.
Right.
Thank you.
Okay, that's good. So we go to Ms. Thomas.
Sorry, I'm just curious if we can get paper copies of the motion that has been
I
moved.
think
and
we're trying to do
discussing.
that, but we just can't keep delaying. If you got electronic copies, we're going to get you the paper copies soon.
And the clerk sent the electronic copy?
Yes. That's what I asked everyone, and everyone nodded that they had received the electronic copies.
I don't believe I was a part of that. Thank you, Madam Chair. So I realize that the Liberals have moved this motion and that they would appreciate nothing more than to spend this time debating this motion. I think that's unfortunate because we have a whole host of witnesses who are here with us today. And we have an important study with regards to the Court Challenges Program, Bill C-316, on the table. Essentially what they are doing then is they are opting to hijack the rest of this meeting for the next hour and 40 minutes to discuss a motion that they've put out there. And
Chair.
it is at the expense of the witnesses that are here
That is
testifying.
not a point of order. I'm sorry, but that is not
I
a
don't
point
think
of order.
she had a point of order. She
Well, then
put her
I'd
hand
like
up
to
to
know-
speak to the motion.
I'd like to know why she has the floor, like on the basis of what? She came in basically saying, I don't have the motion, and now we're going into the specifics of this motion.
No, she has the floor to speak, so I'm going to have to let her speak. I'm sorry. She's valid reason to speak.
I just want to understand for point of clarification, Madam Chair.
I have a list of people
Member
wishing
came in
to-
basically saying, I don't have the motion. I understand that. And
I
then
can clarify
basically
it for
she
you.
was told it was sent by email.
And I
So
think
did she put
was
back her
reading
hand
it.
up?
Yeah.
Did she put back her hand up? Because there's other
You're
speakers
embarrassing
that had their
yourself.
hand up before she did.
Floor. That's not how this works. Point of order. She had the floor. She can talk
Sorry,
about whatever she wants
I
as long
don't
as it's
think we
relevant.
need
She
points
did
of
that.
order here, Philip. I think Ms. Thomas has the floor. She did not stop speaking, and she had her electronic version. Go ahead, Ms. Thomas. Continue to speak.
Thank you. I'll just clarify for the honourable member across the way. I had my hand up, which means I was acknowledged as the first speaker on the list. First off, I needed to make sure that I was speaking to the correct motion. That's what a responsible member of parliament does. And then after I was able to verify that, I was able to speak to it. And so I'm continuing with the time that's been granted to me by the chair.
Whose point of order is this?
Michael Koto.
Yes, Michael.
I put up my hand from what I, right when the motion was being moved, I put my hand up. So I assume that I was the first speaker and the NDP member was second.
I'm going by the list that the clerk has of when she noted hands up, and you are the third speaker, and Ms. Ashton is the fourth. So, Mr. Saray, is your hand up? No, okay. So I'm sorry, Michael, that's the list I have from the clerk. Go ahead, Ms. Thomas.
Thank you, Madam Chair. Madam Chair, what I was stating is that we have a whole host of witnesses who are here. They've come to speak to Bill C-316. The motion that is on the floor brought forward by the Liberal members is something that can be debated at any point in time. It's common that a motion be brought forward when we have witnesses here, but most often a courtesy is granted and the motion is moved toward the end of the committee meeting in order to respect the time of our witnesses. I do wonder if Ms. Romanato would agree to perhaps in a friendly way withdraw the motion and then could move it within a matter of time when it comes back around to the Liberals' question period. Again, it gives an opportunity to question, I should say. It gives the opportunity for the motion to still be moved, but it also gives us the opportunity to respect the time of our witnesses. In a friendly way, I'll pose that to Ms. Romanato, but I would just remind the chair that I do still have the floor, and if she's not amenable to this friendly suggestion, then I wish to speak.
I think we could probably deal with this quite quickly.
She did have the floor when she posed it, and it had been sent to everyone on May the 2nd, I think. And so, you know, there was enough notice of this motion coming forward. It being tabled right now means we have to discuss it. And if Ms. Romanato does not want to move it forward, I think you continue to have the floor, Ms. Thomas, to speak for or against the motion.
Thank you. I would move a motion that we that we adjourn this debate and that we continue to hear from our witnesses today.
We'll have to call a vote on that. Does everyone feel we should call a counted vote on this?
Yes, I would like a counted vote.
Okay, so clerk, please.
The vote is to adjourn debate. Mr. Couteau.
No.
Ms. Latanzio?
No.
Monsieur Sampson?
No.
Madame Romanado?
No.
Monsieur Seri?
No.
Mr. Waugh?
Yes.
Ms. Thomas?
Yes.
Monsieur Gourde?
Oui.
Mr. Lawrence?
Oui.
Mr. Champoux?
No.
Ms. Ashton?
No.
Yes pour 4, nays contre 7.
Thank you. So the debate continues. Ms. Thomas, I'm going to move to the next speaker unless you want to continue.
Thank you, Chair, for checking in with me. I appreciate that. That's very kind. I am good to cede the floor for now. Thank you.
Okay, thank you. I will now go to Mr. Howard.
Thank you very much, and I am disappointed that at least we didn't have the courtesy. I mean, it was really through the courtesy of my colleague, Mr. Champoux, that the Liberals even had the ability, because otherwise they would have blown through the time. But it's unfortunate that courtesy was taken advantage of. To move a motion that is clearly partisan in nature and is meant to obstruct our study, which is strange because it's led by a Liberal member. I thought we were having a constructive conversation, and I thought there was some excellent witness testimony, I might say, from all witnesses, from Liberal, NDP, and Conservative witnesses, and would have very much liked to carry forward. I know Mr. Serre has been waiting patiently to get his legislation through, and have a lot of respect for the member, so it's disappointing that they've decided to obstruct and their own legislation, but we will be reviewing and providing more in-depth feedback with respect to this motion. But I think it's fair to say that it requires some changes to take some of the partisan bite out of it, and to move it to an area that is important. And of course, all parliamentarians want to make sure that we protect all peoples, and that everyone feels safe, regardless of their gender, sexual orientation, race, culture, ethnicity. I believe that all 338 parliamentarians have it in their heart to make sure that everyone gets an opportunity, whether you're born in Alderville First Nation, downtown Toronto, downtown Vancouver, regardless of who you love, that you're treated with respect and dignity that all people deserve. I know that from earlier that Mr. Coteau has spent some of his life fighting racism, which I think is brilliant, and have appreciated his service. I think this is a very serious issue. I'm disappointed by the partisan tone of the motion. I think it is something that we could all work together to fight racism, to fight discrimination in all forms. And so just one area that I guess I'm seeing is missing. Maybe you could put it underneath religious minorities, perhaps, but I would specifically like to see anti-Semitism called out, which we don't have in this. And I'll actually bring back, just discuss a motion that Conservatives brought forward that unfortunately was stonewalled by Liberals, and so I would just like to read into
Mr. Lawrence,
record.
we are now debating a specific motion on the floor.
Yeah.
You cannot read another motion right now to discuss it.
I can read it for context. I'm not moving it. I'm not giving notice of it. It's just a context. It's no different than reading.
All right, go ahead then.
A piece
Continue.
of Hansard or something. So,
Continue.
Yeah. So Conservatives brought the following motion. Given that, according to a National Post article published on April 17th, the York University Faculty Committee has presented a list of anti-Semitic recommendations that include labeling the support of Israel as anti-Palestine racism, classifying anyone who supports Israel as anti-Palestinian, Islamophobic, and anti-Arab, granting academic freedom and free speech to pro-Palestine students while revoking the same rights from Jewish students and anyone supportive of Israel, and identifying Zionism as a settler colonial project and ethno-religious ideology that should be isolated and destroyed, and that the Government of Canada has committed to a Canada anti-racism strategy, and that the Minister of Canadian Heritage is responsible for fostering and promoting Canadian identity, values, cultural development, and heritage, and the 2024 University's Anti-Semitism Report highlights...
Mr. Lawrence, I don't know if this is a filibuster or not, but this has nothing to do with the motion on the table. I'm sorry. The motion on the table is to study far-right extremism and the role it plays in misinformation and disinformation. So I think this is something that I would like to ask you to stick to the motion, please.
I am. So the part of it says here, and this is the part that I'll relate back, and harassment towards journalists, women, Indigenous peoples, Black and racialized communities, and members of the 2S LGBTQI plus community and religious minorities. I'm talking about, and I'm hoping that religious minorities and harassment would include anti-Semitism. I certainly hope that's the truth.
I would hazard a guess. I'd ask Mr. Arminado to explain, but I would suggest that religious minorities means all of the religions in Canada.
Right, and I that's why I want to talk about the importance of fighting anti-Semitism in Canada, and that then brings me back to this to the motion that was unfortunately was stonewalled by the Liberal Party. The committee unequivocally condemn anti-Semitic conduct of this faculty committee at York University and report this to the House. And so they said, I as a practice, I never try to impugn the intentions of other members, as I believe we are all honorable, all 337 of us. I believe that we all want to fight the scourge of racism and anti-Semitism. But just to show that clearly this motion needs to be amended to include the fight for anti-Semitism, I'm going to just ascribe that to an oversight. Although I will express my disappointment from the Jewish community, I certainly heard from them about the failure of this committee because of Liberal stonewalling to pass a motion clearly calling out anti-Semitism, and it would just be an absolute travesty if we were to do that twice. The Jewish community is under incredible pressure. Regardless of what's going on in Israel or Gaza, I have talked to many parliamentarians, I've talked to many in the Jewish community that don't feel safe, that feel like they are under pressure. And you know what? I have to tip my hat to Anthony Housefather, Liberal NTP, just show you that I'm nonpartisan here, in his calling out of the city of Ottawa for their refusal to celebrate Israel, and because they couldn't guarantee the safety. I think Anthony Housefather is 110% right when he said that it is the obligation of our country, it is the obligation of all of our police forces to protect our individuals of any.
Point of order. Madam Chair, I have the impression that Mr. Lawrence is talking about something that falls under public safety and not under Canadian heritage. I do not disagree with what he's saying, on the contrary, but I think we need to come back to the topic of the motion before us. If we want to have an opportunity to get to our witnesses and to the study of the day, we should stick to the content.
Thank you.
Je comprends mon discours.
I totally understand. I have a lot of respect for my colleague.
My apologies to my friend. So this contemplates the harassment of religious minorities, and I think it's important to specifically call out anti-Semitism. And if there is not a mention of, I thought I saw it, but maybe I did not, there also should be a specific call out for the protection against Islamophobia as well. I think... Sorry? I'm going to discuss it. I do have a wide latitude, and that is the rules in Boston.
And so my question is, if you're going to filibuster, I may have to let the witnesses know they can leave.
I am not.
So I just need to know for the witnesses' sake.
Madam Chair,
please, I'm speaking.
I do believe it would be wise to probably at this point to allow the witnesses to leave, as I don't believe this is an easy or simple conversation.
Go ahead, continue. Mr. Lawrence, you have the floor.
Thank you. And so, as I was saying, given the charged nature of which we currently live in, the division that unfortunately is a real scourge on our great country, I think it's important that we parse our words very carefully. As I said, I believe that specifically we should be calling out Islamophobia as well as anti-Semitism. And I was just talking about the liberal member Anthony Housefather, as well as our Melissa Lanceman and Marty Moran.
Madam Chair?
Yep.
I have a point of order.
Ms. Ashton? Yes.
I think it's pretty clear we're witnessing a filibuster on a motion to study the rise of the far right. The far right is clearly anti-Semitic. It is clearly Islamophobic. This is exactly what we want to look into. So I don't understand why the Conservatives are wasting our time and why we don't get to vote on this motion. If they believe that they want to look into anti-Semitism, then let's see them vote for this motion and let's cut this filibuster. We're wasting the witnesses' time. We're wasting all of our time.
This is not a point of order.
This is not a point of order.
Madam Chair, this is not a point of order.
Sorry, I'm the chair. I will rule on whether it's a point of order or not. Ms. Ashton has a point of order because she's referring us to get back to the order of what we're doing, which is to discuss a motion. And I must say that, Mr. Lawrence, you're drifting as far from that motion as possible. So I think that she's calling for us to get back to the order of the motion. Thank you. So there we go. Now, thank you, Ms. Ashton, for your point. Mr. Lawrence, you will...
Yeah, and I, you can characterize this however you want, Chair, but you can read back the comments on the Hansard. We are talking about racism, anti-Semitism, Islamophobia. It's all in this. It's all in here, and that's what I'm talking about. And quite frankly, I think my comments are constructive, and I would actually welcome to have the conversation of whether I believe we should include directly in this proposed study Islamophobia, because I believe that to be a scourge, and certainly talking to many of my Muslim friends, they have also commented to me that they don't necessarily feel safe. Mr. Noor Muhammad in this very committee recounted his own experience growing up, that he often felt like he was prejudged just because of his faith. And I don't think anyone should live that. And I think that including it specifically within this study is absolutely critical. And I think and getting back to my original point, though, which is what I was going to get to, is I have heard Mr. Mendicino, Mr. Carr, Mr. Housefather, amongst many other Liberals, talk about the scourge that is anti-Semitism, and of course I've heard Conservatives call it out, including Mr. Morantz, Ms. Landsman, and our leader Pierre Poilievre. But I think it's important that we do, if we're going to have a forum meeting study on this, that we do understand some of the background. And so I do want to add a little bit of context with respect to anti-Semitism in Canada. Canada actually has the fourth largest Jewish community in the world, with over 390,000 Jews, and many of the folks who I know of Jewish heritage or Jewish religion, however you wish to characterize it, have direct roots to the Holocaust. And I myself am actually a part Jewish heritage as well, and so on my grandmother's side. But when you hear the stories of the Holocaust surviving, and really how the storm that eventually came to be the Holocaust in Germany arose, they're horrific, and so I mean, others might question why I want to include anti-Semitism in this study, but I think it's critically important. Here's just a brief look into the world of folks of the Jewish heritage. So here's just as what has happened in the last very recent history: vandalism, graffiti, circulation of hate propaganda, intolerant and racist language in places like Twitter, and comments on web forums and blogs. There's been bomb threats against Jewish schools and community centers, including not very far from where we are. The intimidation of Jewish students, we've heard that even on our university campuses, which are there to be a place of safety and of growth, and yet our Jewish students often, unfortunately, feel unsafe. And so I'll continue here. So there's been significant progress and I would hate to see that reversed, as the last 6 months since October 7th have been extremely challenging for our country, and we've seen a rise of both, I might say, Islamophobia and anti-Semitism, and I think that needs to be, quite frankly, a focus of the study if we want to study hate in our country. And so, for example, police...
Point of order?
Yeah.
Who is that? Michael?
Michael Koto.
Yes, Michael, go ahead. Let's hear your point of order.
I would just ask the member to add Islamophobia and anti-Semitism to the motion, and let's move forward. I think that's what he's getting at.
Well, I had originally asked a member if he had an amendment, and I'm hoping that we will get an amendment from him because he's made his point. And so maybe, are you going to propose an amendment, Philip?
I have the floor for as long as I want. Is how
I know
this
you
works.
do. I'm not asking you to cede the floor.
It's
I'm
very
asking
simple.
you if you're suggesting certain things be added. Is that going to be an amendment that you're giving us?
It likely will culminate in an amendment. I do want to put down the context. This is extremely important, and I will not back off one item from talking about the importance of anti-Semitism. And I certainly hope that no one here would get in the way of me talking about the important fight against anti-Semitism. That would be wrong. And quite frankly, members of your caucus would be very disappointed. They've told me. Thank you. Thank you.
Thank you. You finished?
No.
Oh, okay. You said thank you.
Absolutely
I thought
not.
you'd wrapped up.
The fight against
Sorry.
anti-Semitism
Go ahead.
continues on here. Police reported hate crime data indicates that there were 608 hate crimes targeting religion as of May 2021. Of that number, 296 were incidents targeting the Jewish people. And I want to be clear, whether you're targeting a Sikh, targeting a Muslim, or targeting a Jew, one attack on one faith is attack on all Canadians, which represents. Of that number, 296 incidents were targeting Jewish population, which represents a 20% decrease, which represented a decrease in 2018. Which is, as I'm saying, progress was being made. Unfortunately, in recent months, it's been rough. It's been harsh for folks of the Jewish faith there. So I would actually, at this point, like to propose my amendment, and I will propose two amendments here.
At a time?
But yeah, I'm aware you can only bring one amendment, but you can. I should have been more careful with my words. My apologies, Madam Chair. You can obviously amend multiple phrases within one amendment, and that's what I'm trying to do.
All right, go ahead.
Okay. Well, we'll start. Sorry. We'll start with we're going to move it down from 4 meetings to 2 meetings, just because we've got a very full schedule. Like I said, I see Mr. Surrey there. He's desperately trying to get this important bill. And in addition to that, we've also got the safety in sport. We of course as a committee had training with respect to being better listeners and sensitivity, which was important, and we have critical work to do, as this study is too. It's just we are coming down. I believe we have 5 weeks left there, Madam Chair. Thank you, and a total of 10 meetings. And I would like to see our business be done. So I would move that. I would move that we reduce the amount of meetings from 4 to 2. And at that point, I will cede the floor.
Thank you. We have an amendment on the floor, and it will read, pursuant to Standing Order 1082, the committee undertake a study of no less than 2 meetings. So, any discussion on the amendment? If no discussion, we're going to call the vote on the amendment, please. Oh, you have your hand up, Ms. Thomas, to discuss the amendment?
I thought they had their hand up too. Or is that...
All right, Michael? Michael, then
I'm going to
Nikki.
speak to the main motion.
All right, so Nikki, do you speak to the main motion or the amendment? Thank you. Okay, so I then have Ms. Thomas to the amendment.
Thank you very much. I appreciate that. So the motion put forward asks for a 4-meeting study looking at extremism in Canada, and in particular far-right extremism in Canada, and the impact that has on some communities that have been selected here by the Liberal Party of Canada, including journalists, women, Indigenous peoples, Black and racialized communities, members of the 2S LGBTQ2I plus community, and religious minorities. As you can see from this list, there are many folks who are omitted. Among them, of course, would be the Jewish community in Canada, which is actually the most harassed community in our nation at the moment and has been for quite some time. If we look at the crime rate and the hate crimes that are committed against folks, certainly Jewish individuals are the most targeted. And so I'm confused as to why they're not on this list. Nevertheless, the amendment that we have moved here today calls for a 2-meeting study. And the reason for that is this. This committee is already undertaking quite a bit of work. The Liberal members have said again and again and again that their supposed priority is the Safe Sport study, yet they continue to move motions like the one that we have in front of us, which take up time and take precedence over the Safe Sport study. We spent quite a bit of time hearing from witnesses with regard to the impact that was had on them by abuse in sport. That report was drafted once, and then some edits were made, and then it was redrafted. And that second version is now in front of the committee, and we're waiting to review it. That review is scheduled not at the next meeting, but the meeting after. And so to accept this motion that is in front of us would actually delay that report further, which, as the Liberals have highlighted in the past, and I'm not sure if it was genuine or disingenuine given the conversation today, but they've commented in the past that that is priority for them, that it is of utmost importance, and yet, again, they continue to put hurdles in front of the completion of that report. So that baffles me. And I think it baffles a lot of other folks as well, who took the time out of their busy schedules to come and testify here and share their stories with us concerning the impact that abuse in sport had on them. And now this committee continues to delay and not complete that report and get it into the hands of the public. I think that's unfortunate. I think that's a misuse of those individuals' time and energy and also emotional investment. I think it's actually an abuse of their trust in this committee and our ability to get things done. The Safe Sport study is meant to take precedence after completing the bill that is in front of us. And so I am confused as to why we wouldn't make that happen. To change this study then that has been proposed, to move it from 4 meetings to 2 meetings, would allow us to get on with the business of this committee, I guess, and to complete that report with regard to safe sport in Canada. This would be respectful of the witnesses who came and shared with us their testimony concerning their experience within sport. It would be respectful of the members of this committee who have invested over 2 years in this study, which I will observe that there is only one permanent member of this committee at this table right now. And so to be respectful of those who have invested a great deal of time and energy, and to be respectful of those witnesses who showed great vulnerability in sharing their stories with us, I do believe that we should prioritize the completion of that report, which means that it would require a shortening of the study that is being proposed here today by Mrs. Romanato by way of moving Mr. Nur Mohammed's motion. Further to that, I would highlight to the committee that once the Safe Sport study has been completed and that report has been drafted, the next study on the docket has to do with online harms. And that is a study having to do with women and girls who have been subjected to immense harm online. For many, it's because images were taken of them without their consent and then plastered.
Point of order, Madam Chair.
Yes, sorry, Nikki. Go ahead.
Yeah, I think we're all familiar with what's on the docket. We're all in part of this committee. But I think what we're seeing here is a continued attempt by the Conservatives to filibuster a motion to study
Madam
the rise
Chair, this
of
is
the
not a
far
point
right.
of order. This is not a point of order.
More than 2 sessions.
I decide whether it's a point of order or not. I need to hear Miss Ashton out. She is actually speaking to the order of the day, which is that we have an amendment on the table. She's speaking to that. And so I think she has a point of order. Go ahead, Miss Ashton, finish what you were saying.
Thank you, Madam Chair. To conclude, we all know what's on the docket. We're talking about 4 sessions for a scourge that we're seeing across the country, the rise of the far right. I just don't understand why the Conservatives have such a problem with spending 4 sessions to look into the rise of the far right. When will they stop filibustering, and let's get to a vote?
Thank you, Ms. Ashton. Point of order. Now, Ms. Thomas, you wish to continue?
Thank you, Madam Chair. And so as I was saying before being interrupted on a non-point of order, we have the next study that is coming up after the Safe Sports study, should we complete that, is an online harm study. And that study is a 2-meeting study. It's very short. It's been on the docket for almost 3 years. However, due to the Liberals' gamesmanship, it has been punted numerous times over out of a refusal to study, which I think is really sad, because at the end of the day, what that study is about is women and children who have been violated because images of them have been shared online without their consent. What it also looks at is children who have been subjected to the creation of pornography, and then to have those videos or those images shared online, again, of course, without their consent. Truth, it wouldn't matter if they consented or not. It's child pornography. That's disgusting, and that's illegal. But these things, the illegal creation of child pornography and the spreading of images of individuals without their consent, is causing irreparable harm to women and girls in this country. There are dozens of stories that have been shared in Parliament to this effect. And there are many who have committed suicide, taken their own lives, because they could not continue to handle the degradation that was coming their way because of the bullying or mistreatment. And so a study was brought forward, again, almost 3 years ago, to look at this issue because it matters. And that's a Conservative motion that was brought forward, and it was determined through all party support that it mattered enough to study, that it mattered enough to look at here. And again, here we are with the Liberals having put forward yet another motion that punts that study further down the road.
Point of order, Chair.
Yes.
Michael Cotto. Considering we've got half an hour left, do you think at this point we should ask the witnesses to leave? It's obvious what the Conservatives are doing.
Thank you, Mr. Cotto, and I will ask the committee if they agree that we should ask the witnesses to leave. So I shall thank the witnesses very much for taking the time to come to this meeting. I'm so very sorry that we have what is happening, and so I'm going to thank you for your presentation. I'm sorry we couldn't get any more of your wisdom in the answers to this bill. Thank you very much. You may leave. Thank you. All right, Ms. Thomas.
Thank you, Chair. And so, as I was saying, to further punt this study with regard to online harms that are caused, harms that are caused to women and girls because of these images being shared or created, to further punt that study, I believe is altogether irresponsible of this committee as a whole, and I think points to I don't know, something that is uncaring or unkind about the Liberals' approach. to not want to give that attention and to continue to delay that for nearly 3 years. And so I guess we have a middle ground that we're offering to come to, and that is instead of 4 meetings that the study proposed to us today would be 2 meetings. It would still allow the study to take place, but it would also allow us to move to complete the Safe Sports study and therefore honor the witnesses that came and were a part of that. And the many athletes and parents and coaches that were represented by those individuals who came to this table and had a voice on their behalf. The second thing that it would allow us to do if we were to move down from 4 to 2 meetings is it would allow us to hopefully still complete the online harm study before the end of June when the House of Commons breaks for the summer. At least that would be the hope. One cannot anticipate what games might be played, but that would certainly be the hope. So the point is that we're asking to meet in the middle. We're proposing that the study be for 2 meetings.
Thank you, Ms. Thomas. You finished? Thank you. I now have Mr. Waugh. To the amendment, Mr. Waugh.
Yeah, to the amendment. Thank you very much, Madam Chair. It's kind of interesting, you know. There's so many forms of extremism in this country that they're worthy, all of them, to be examined. So I look at the motion here, and it only mentions one kind of extremism. And I was really disappointed because it's turned this into what I think very political. You know, the Liberals, Madam Chair, have...
Point of order.
Yes, Ms. Latanzio.
I'm sorry to interrupt my colleague, but I'm just, like, we're on the amendment, right? So the proposed amendment is from 4 to 2 meetings?
Yes.
And so that's what we're speaking to.
We're going to debate that
We're debating the duration of the study.
I did ask Mr. Waugh if he's going to speak to the amendment and not to the full motion, Kevin. We have to speak to the amendment, which is a proposal of 2 meetings.
Yep.
Just on that point of order, Madam Chair.
Yes.
It is clear. Say law, but it's a clear tradition and that members are given a wide latitude, and so talking about the substance of the study within the amendment is more than within the rules. And certainly in my 5 years of Parliament, I've heard much further wanderings from the substance than what Mr. Waugh was doing.
Mr. Waugh, go ahead.
Thank you, Madam Chair. All I was going to say, the Liberals proposed this discussion, then voted against postponing the discussion to allow us to hear witness. So I think it's a bit rich to blame the direction of this meeting on us. You know, our timeline is very tight. We need the minister by the end of May 30th. We haven't heard from the minister in a while, and she has been invited for the main estimates. As you note, Madam Chair, there's only maximum 8, maybe 10 meetings left before we rise for the summer. I'm concerned with, and I know we're going down to 2 meetings on the amendment, but I am concerned on the amendment, and I'll tell you why. In 2009, unbeknownst to me, my wife and I got my daughter to the March of the Living for Educators. It was 2009. We sent our daughter over to Poland for the Holocaust. And I think to move ahead now, kind of 14, 15 years later, I am so thankful that we scraped together that money for her to go over, learn about the Holocaust, teach it in our classrooms. And now when I see this motion in front of me, I'm a little disappointed that it doesn't include anti-Semitism, because we're dealing with it in every city, if you don't mind. So the 2 meetings would bring us towards the end of May, because we got the minister coming. And as duly noted by MP Thomas, we do need to hear from Safe Sport. You have had a lot of emails, Madam Chair. I have had dozens of emails on Safe Sport. It was, outside of Hockey Canada's inquest, I would say the second biggest item that we have dealt with in a number of years in the Canadian Heritage Committee. So I just throw that out there. We just got the report. Thank you for the analysts working day and night to get the full report to us. And now we have some recommendations on safe sport. The whole country is waiting for that report. And I can see now it's going to be delayed until probably the first part of June, which is too bad. But that's all I'll say on this. I was a little disappointed on the motion that it did not include anti-Semitism, since that is first and foremost, I believe, in this country that we've seen from coast to coast. Thank you.
Thank you, Kevin. Your hand is still up. Michael, are you speaking to the amendment? Or are you speaking to the motion?
No, I will. I'll speak to the main motion, but actually, I'll just say a few words on the amendment. I'll just reserve my time for the main motion. Thank you, Chair.
Thank you. Any further discussion on the amendment? Yes. Well, Philip, you made the amendment, so you'll be closing it. Sorry. Nikki, on the amendment? No, on the main motion. Okay. Martin?
Madame la Présidente, juste pour être certain.
Madam Chair, just to be sure, before the amendment is tabled, I put my name on the speaker's list to speak on the main motion. I hope we'll be coming back to that main list afterwards.
That's why, if Mr. Lawrence speaks, he would be wrapping up the debate on his amendment, and then we can call a vote on it. So, Mr. Lawrence, your hand was up.
Yes, thank you, Madam Chair. Appreciate that. And so, just this is an incredibly important topic, and I want to make sure that everyone's clear that I'm saying that. I do want, though, and I wish that this was raised perhaps in a subcommittee, so we could have properly planned out the calendar. I'm relatively new to this committee, but the other committees that I've been on, usually there's more of a structured approach to the schedule, even if there is some disagreement as to how that schedule will occur. And so I believe that the motion calls for currently 4 meetings. We want 2 meetings, but it doesn't give us any type of timing as to how or when we're going to do that. And so as I look at the calendar here, we have scheduled, when we come back, we have 3:16. I believe it's scheduled for clause by clause, although we haven't gotten nearly through the witness testimony, so I don't know whether that's going to be changed. And then we have Safe Sport scheduled for the 23rd of May, and then Safe Sport for the 27th, and then for the 30th we have main estimates, and then we just have on June 3rd and June 5th we have online harms, and that's without getting any of our other business done that's important. So just maybe a point of clarification. I would just ask in a friendly way, if we have unanimous consent, to having the other side just what their thought was as to when we would schedule this study for. I know it's a little bit of break in protocol, and I'd like the floor back. But if you're willing to express that, it's great. If not, that's fine. You don't have to. It's not your obligation. But I was just curious.
Let's get as much clarification.
So the clarity is there is no date in there, so it's up to the will of the committee when they'd like to schedule it. So there's nothing's getting punted if that's not the will of the committee.
Okay, no, that's fine. It's just in my short time, and I believe the Deputy House Leader, Ms. Ramadano, has I got that right? So I know that you're well aware of, very well aware of how to schedule the House and committees. It's just this committee sometimes has not operated, with all respect to all the members here, I don't think it at maximum efficiency, so we're going to just put the study forward without putting any dates up. I would just hate to see us not getting our business done such as getting through 316, of which I believe there was already an extension requested and granted by the House, and then the online harms, as Ms. Thomas said, was is a very important study, as well as safe sports. And certainly, even not being on this committee, I have heard a lot about the importance of that study from my stakeholders. But so it's with those reasons that I would I guess close the debate unless there's someone else on the amendment to go from 4 to 2 meetings. Then.
So the debate is now closed. So we will be calling for a vote. Would you like a on division? Thank you. Go ahead, clerk. Thank you.
The vote is on the amendment to reduce the study to 2 meetings.
Yes, to reduce to 2 meetings from 4.
Mr. Coteau?
No.
Ms. Latanzio?
No.
Monsieur Sampson?
No.
Madame Romanado?
No.
Monsieur Seri?
No.
Mr. Waugh?
Yes.
Ms. Thomas?
Yes.
Monsieur Gourde?
Oui.
Mr. Lawrence?
Oui.
Monsieur Champoux?
Oui.
Ms. Ashton?
No.
Yes pour 5-5, nays contre 6-6.
Sorry, those against were 6. Were 6. Okay. All right. So the amendment does not carry, and we now go back to the motion unamended. Any discussion on this motion as unamended? Michael,
oh,
sorry, Michael, you're next on the list. I'm sorry, Michelle, you're next on the list. Yeah.
Thank
and
you
then,
so much,
and then
Chair.
Miss Ashton, and then Miss Thomas, and then Mr. Waugh, and then Martin. We have a list. We keep a list. The clerk is sure that I don't do anything wrong with the list, so I'm assuring you. But just before we get to Mr. Coteau, I would like to clarify something, Mr. Lawrence. You say you've only been on this thing for a short time, and we don't follow the instructions. We started in this session with a clear idea of what the subcommittee wanted, and the committee agreed to it. And then every time we were trying to stick to the schedule, a committee has the ability to decide what it wants to do. And we have had many motions put forward by political parties to move us off the agenda. I have pled with this committee on the safe sport. And I think it's not a case of what I do as a chair or the clerk does. It's a committee deciding what it wants to do or not do. So I think we should go to the main motion.
Just a brief point of order there.
Mr. Coteau, sorry,
Just a
yes.
brief point of order, Madam Chair.
Yes.
I just wanted to say I was certainly not in any way attempting to blame the chair. And I think that both you and Kevin have done a great job. It's just, as you rightfully pointed out, the committee members, we have sometimes had challenges as to getting onto it. So in no way did I mean to impugn you
I am not.
or Kevin.
Sorry,
I think you guys
Caleb,
are
I'm
both
not
great.
taking personal umbrage here. I don't usually take personal umbrage. I'm just pointing out for clarification that we had a decision about where we were going to go, and each time we were moved off that decision by various things coming up. I want to point that out, and it's come up not just from the Liberals on this motion, it's come up from many political parties before that. Now, Michael, you have the floor, the motion.
Thank you very much. Thank you very much, Chair. And I want to start by saying I'm very disappointed with the Conservatives for spending over an hour discussing the length of the study and, categorizing this motion as partisan. There's a mainstreaming of extremism in Canada that's taking place. And I think it's our duty as politicians to call extremism out. The far right has been growing over the last decade in this country. During COVID, we saw a rapid rise of not only extremism, but misinformation and disinformation. And we know all forms of extremism impact all communities, including the Black community, Indigenous, and religious minorities, like the Jewish community and the Muslim community. You know, it's our job as politicians to call these things out. The only way extreme hate and extremism in the far right grows is when we're silent on these issues. And this was a very, very simple motion. And I want to go through the motion just quickly because, you know, remember the Conservatives actually said that that this motion was partisan. And you know, to me, that is unacceptable because the motion is very clear, and I want to thank the member who moved this motion for bringing this to the forefront. But I want to go through the content of this motion so Canadians who are listening have a very clear understanding of what's being discussed and what the Conservatives are calling partisan. So the first part of it asks for 4 meetings. And it's to study the rise of far-right extremism in Canada. It wants to examine how misinformation and disinformation are used. It wants to put in better support services, preventable measures to combat this extremism. And it wants to look at how extremism, far-right extremism, impacts journalists, women, Indigenous people, our first people of this country, Black people, racialized communities, and members of the 2SL LGBTQ community, and religious minorities. Madam Chair, that includes the Jewish community and the Muslim community and all religious minorities in this country. In fact, if the members wanted to be more specific, I would be very open to that as well. But that's what we're debating here. And I cannot understand why, for the last hour, the Conservatives would delay, would go in all different directions, and actually to a point where we can't even listen to our witnesses on this important study we're doing. It's completely unacceptable. This is not a partisan issue. This is about building a better country by exposing what's wrong. And I would say without a question, the number one role of Canadians, of politicians, when it comes to extremism, is to call it out. Extremism flourishes when people are silent. It works in the darkness, in corners of different parts of this country, in places on the internet that we couldn't even imagine. You know, this is how it works. It's a very sophisticated network. And I would really stress to all members of this committee, including the Conservatives, not to take this stuff lightly. Now, I understand there's a sticky point here because the leader of the Conservatives, who recently visited a camp where there were extremists and was called out for it, and he decided not to denounce them. And this has been on more than one occasion. He has pictures taken with the far right, marches
Point
with
of
them
order.
in some cases.
Point of order.
Who is this?
And this is
It would be
exactly
Kevin.
what
Oh,
they'll
sorry,
do.
Kevin, go ahead.
Point of order.
This is
Mr.
exactly what the Conservatives will do.
Sorry,
This is
Michael.
a great
Point of
example
order.
right now.
Michael, I have a
Just for
point of
people
order on the
watching.
table. I need to listen to it.
I should remind the member.
Example of far-right extremism to have a member.
I'm sorry, Ms. Thomas, you do not have the floor.
I do have
Mr.
the
Waugh
floor.
has the floor. Ms. Thomas, you do not have the floor. Mr. Waugh called out, he put his hand up, and he has got the floor. Please, please, please. A little bit of respect for your colleague. Mr. Waugh, go ahead.
Yeah, you know, Madam Chair, here we have a member talking about my leader. Should I talk about your leader on blackface? You know, tit for
It's not
tat
a
here,
point of
Mr.
order,
Cotto. Madam Chair, we
If he
have the
wants to
Prime
speak,
Minister
he can
that
say
went
anything he
around
wants, but
blackface in this
That's not a
country.
point of order. They're interrupting me again.
I'm interrupting, Madam Chair, because I'm just pointing out, if he's going to take a shot at...
Thomas, please.
Yes,
Madam
please.
Chair, I'm just
Go ahead,
pointing out.
Mr. Ward.
I was just pointing out.
Put his
He's
name on the
taking a
list.
shot at my leader. I can take a shot
Put
at
your
his
name on
leader
the
about
list,
blackface.
Mr. Wall.
Okay, thank you, Mr. Ward. That was not a point of order.
Point of order.
Mr. Cotto is bringing up his arguments for the motion, and so he's allowed to do that. I heard arguments today for a whole lot of things that I think strayed away from the motion itself. So, but thank you for speaking up, but I don't consider that to be a point of order.
Point of order.
Go ahead, Mr. Cotto.
Point of order.
Thank you.
Madam
Thank
Chair,
you,
I have a point of
Madam
order.
Chair.
Ms. Thomas.
Thank you.
Point of order. Go ahead.
Mr. Cotto just accused my colleague, Mr. Waugh, of being an example of far-right extremism when Mr. Waugh called a point of order. Madam Chair, I would invite you to make a ruling on that, because that is... Madam Chair, why are you allowing the member to speak over me right now when I have the floor granted by you?
I was just about to press the button to speak to exactly that, Ms. Thomas. You presume to know what goes on in my head
Madam
and
Chair,
in everybody's head.
I am simply asking you to bring this committee to order.
I am about
held the
to do
floor
that if you would allow me
gave me
to.
the floor, Madam Chair.
Yes.
And then you allowed Mr. Cotto to step in and start speaking over me.
Thomas, I'm not going to fight with you because you seem to relish doing that. I am just saying that I was about to press the button to tell Mr. Cotto that Mr. Waugh had the floor, that you had the floor when you challenged me about not doing it. So please, let's get on with whatever you have to say. Ms. Thomas, go ahead.
Madam Chair, when you gave the floor to my colleague, Mr. Waugh, on his point of order, Mr. Cotto interrupted and said, here is an example of far-right extremism. That is unparliamentary. A point of order was raised by Mr. Waugh, and for Mr. Cotto to call that an example of far-right extremism is absolutely inappropriate. And so I would ask you as chair to make a ruling on that. Are you allowing that type of accusation to stand at this committee, or are we going to ask Mr. Cotto to withdraw his comment?
Can I speak to it, Madam Chair?
Excuse me, Mr. Cotto, speak to the accusation made towards you.
Yeah, thank you. Thank you. I actually find Mr. Waugh a gentleman. I find him a very good parliamentarian. The point I was making, this is a perfect example of delay tactics that are being used. If there's any offense to Mr. Waugh, I do apologize, because I actually find him to be a very kind and a very dignified politician. So I don't know what the interpretation was with the member, but it was that accusation is quite silly.
Thank you, Cotto. Now, will you finish your discussion on the motion? Thank you.
Yeah. So my point was this, is that we have leader of the opposition, the official opposition. You know, this is a person that holds a lot of influence and power in the House of Commons, but also a lot of influence across this country. To go into a camp of far-right extremists, to march with them, to shake hands with them, to have pictures, and to be called out on these exchanges, and not to retract his actions, not to speak to those issues, is exactly what the problem is when it comes to how we combat extremism in this country.
Point of order. That is just patently false. The leader of the opposition has condemned this group, and this group has threatened his wife. So this is really out of bounds.
That's not a point of order, Mr. Lawrence. Sorry, go ahead, Mr. Cotto.
Could you imagine this group has, and I'll just use Mr. Lawrence's terms, that has, I believe he said, the group has threatened his wife. Could you imagine this type of threat made to a politician's spouse? And yet, for some reason, Mr. Poilievre goes into this camp where clearly it was identified that there was there were folks who were connected to this extreme group, and yet the leader of the opposition has not apologized or spoken to this issue. I haven't heard him say anything to retract or to apologize for his actions. And I use this example because when we have people in these high-profile positions. It could be in business, it could be in politics, it could be in education, who are not speaking out against far-right extremism. This is what allows our country to fail. And I think this study is, again, I'm quite happy that this study has been brought forward, so we can look at how far-right extremism is impacting, the trans community, racialized community, how it's impacting women in this country. There's been a connection to gender-based violence on this specific issue. So I think that I'll end there, and again, thank the mover for this motion, and I'll end there. Thank you very much, Madam Chair.
Thank you, Mr. Coteau. Ms. Ashton, thank you for your patience. You have the floor.
Thank you very much. In fact, in line a bit with what we heard from Mr. Coteau, I know we in the NDP feel very strongly about the Leader of the Opposition's visit with the convoy camp, and I would like to put forward the following amendment to the motion to be placed after the words "the committee" in line 1. Condemn the leader of the official opposition for visiting a convoy camp that celebrated far-right extremists and a group whose founder was referred to as a violent extremist by Canada's Integrated Terrorism Assessment Centre. And carries on to the rest of the study, or the rest of the
Sorry, could you repeat
language.
that, please, Ms. Ashton, your amendment?
Yeah, and we can send you the language. So following the word the committee in the line 1, we would add condemn the leader of the official opposition for visiting a convoy camp that celebrated far-right extremists and a group whose founder was referred to as a violent extremist by Canada's Integrated Terrorism Assessment Centre. And.
Okay, thank you. So you finished speaking to this. Your amendment is on the table, so I'm going to entertain debate on the amendment by Ms. Ashton.
Rappel au règlement.
Martin, on
point of order.
Rappel au règlement. Point of order.
Oh, sorry, a point of order. Sorry.
Qui a été présenté par Ms. Ashton, j'aimerais.
Sorry. So I couldn't hear what people are saying. I'm so sorry. Go ahead.
L'amendement qui vient d'être.
The amendment that has just been moved by Ms. Ashton, I would like to receive it in French, please, before we continue discussion or debate on that motion. Could we receive it in writing from the committee? It's a fundamental right, a constitutional right to have the document in both official languages. Thank you.
Suspend while we get it in French. Thank you. motion, the amendment in English and French, thank you, before we begin to discuss it.
And I will make it brief because I would like for this to move to a vote.
Sorry, point of order.
Of course, point of order.
Yes, Ms. Thomas.
Thank you.
Classic.
I don't actually have it. So I have an amendment proposed by Nikki Ashton, but I do not have it within the context of the motion, and therefore I would not be speaking to something in a contextualized manner. It needs to be inserted within the motion.
It is my understanding that Ms. Ashton said it was after the word in the first line, pursuant to Standing Order 108 to the committee, and then her amendment. And then you move on to undertake a study. So the amendment is just put in there and inserted into after committee and before undertake.
Thank you. I can appreciate that. It is customary at this committee that we see the amendment injected into or inserted into the motion before we continue deliberation.
Madam Chair, we've all sat on numerous committees. This is the first time I hear that it's customary. I mean, we've been pretty clear where it goes in the motion. So I feel like this is just another delay tactic from the Conservatives not to vote on a study on the rise of the far right.
Point of order there.
Valid point, Ms. Ashton.
Point of order there on this point of order. I know in Finance Committee that, yeah, we do see it in writing before we vote on it. This is not unreasonable.
Thank you, Mr. Lawrence, for that information. Shall we now speak to Ms. Ashton? Ms. Ashton, you have the floor to speak to your amendment. Thank you.
A point of order.
Yes, Ms. Thomas.
Madam Chair, I think what you're hearing from the members is there's a concern as to what we're discussing, because it is unclear the context of this amendment, and it is customary at this committee. Despite what Ms. Ashton claims, it has always been customary at this committee that we see the amendment inserted into the overall motion, and so that we have a clear understanding of exactly what we're debating.
The generic always, Ms. Thomas. I don't think that's quite true, but there you go. We have, have you received the insertion? I think the clerk has sent it to you now. Yes, she sent you it inserted in the exact spot that Ms. Ashton mentioned it would be. All right, so Ms. Ashton, please continue.
Thank you very much, Madam Chair, and I want to say I'm truly dumbfounded by the delay tactics we've seen from the Conservatives today on an issue as serious as studying the rise of the far right. And I also want to put on the record we've all sat.
Rappel au règlement, Madame la Présidente.
Point of order, Madam Chair. Thank you, Madam Chair. Considering the time and the obligations we surely have, in the coming minutes, we have gone past the time of our meeting, so I'll be asking for adjournment of our meeting because we are gone past 5:30.
Committee, if you recall, the committee started quite late and had some delays because of microphone issues, and so I'm informed by the clerk, I checked before we got here, that we have until 5:55. Thank you.
Madam Chair, I'm not done, Madam Chair. I'm happy to know that the clerk can tell us that we can stay till 5:55 p.m. But looking at our own timetable...
My microphone and I cannot hear a word. Sorry, now can you say it again, Mr. Wood, please?
Tout simplement pour vous dire.
I'm simply saying that in our personal calendars, we had to finish at 5:30. I have other obligations, and maybe other members of the group also have obligations after 5:30 p.m. So I'm requesting consent that we adjourn today's meeting, because if I have to leave, I have to be replaced. We were scheduled to end at 5:30.
Committee, Do I have unanimous consent to adjourn or majority consent to adjourn this meeting? No, I'm hearing no from a lot of people. Ms. Ashton? No, yes, no. Mr. Cotto?
No, I'm fine to stay.
Yeah,
No.
all right. I'm sorry, Mr. Good. We do have this room, and as the clerk informed me, until 5 minutes to, because we had many delays. And if I recall at the last meeting, we faced this question on the opposite side. Everybody wanted to continue past time when we were supposed to end at 5 minutes after 6, and everybody was arguing on the conservative side that we should. So let's try and be fair to each other. If Mr. Good, I'm sorry, we're discussing this motion. Ms. Ashton, you have for sure. We do not have consent to adjourn the meeting. Ms. Ashton.
Thank you, Madam Chair. I would like to speak briefly to the amendment that I've shared. I think it's really important that when we talk about the current rise of the far right, it's not just something that we've seen in our communities. In the events in Ottawa over, I guess, 2 years ago. It's not something that we're hearing of in the news or hearing from constituents or facing ourselves as politicians. It is something we saw on display just a few short days ago as the leader of the official opposition visited a camp where there were members that clearly identified support for Diagolon, a far-right extremist group whose founder was referred to as a violent extremist by Canada's Integrated Terrorism Assessment Centre. This is profoundly disturbing. We know that the leader of the official opposition has not condemned this group, despite the assertions, vague assertions that we've heard from the other side. There has not been a clear condemnation since the leader of the official opposition visited this camp. This is deeply disturbing. We are seeing politicians egg on and practice dog whistles to the far right, and it's incumbent on those of us in committees like this, in parliaments like ours, to take a stand and say and condemn these groups, condemn visiting with supporters of these groups, and condemn the rise of the far right in our country. This is a disturbing trend that we are seeing in other like-minded countries around the world, and it is incumbent on us to show the courage to stand up against hate, to stand with communities that are targets of this hate, and to condemn politicians who are trying to score points by spending time with groups that celebrate these groups and that kind of hate. And so I think this is an opportunity, given these disturbing recent events, like the meeting of the leader of the official opposition, to not just condemn this visit, but more importantly, to support a motion to look into what is the situation right now in our country, the rise of the far right? How is it that communities are being targeted? What are they being subjected to? And more importantly, what can we do about it as parliamentarians? We have a role to put a stop to the rise of the far right, to the rise of fascism within our country. And it starts by showing leadership around this table, supporting motions like the motion in front of us today, and stop playing games to delay the vote on this important motion. So finally, I call a vote for the amendment, and I hope we will have a vote for this motion very quickly.
Thank you very much. And I now go to Mr. Shampoo. Martin?
Madame la Présidente.
Madam Chair, I didn't speak a lot. I haven't spoken a lot since the beginning of this meeting. I didn't even have time, because after the courtesy that was extended to give the time that Madame Latancio had requested, we had a motion tabled. And this is contrary to the habits of this committee to move motions that will disrupt the work of the committee when we have witnesses present. Our committee has really become a real joke. It's disturbing. I hope you're hearing me and listening to the interpretation, because I'm talking to you and to all members of this committee. We have important topics to discuss. We have a timetable that we cannot respect. We have subject matter topics that have been on the table. We have reports that we have to hand in for months. We all have studies that we want to propose to this committee. We're trying to examine a bill. We review the timetable. We change the timetable about 22 times, and we are never able to respect the timetable. And then there are people who are connected to listen to the committee when we want to talk about bills like 316 or things that have to do with online harms for young people. And then now we are disrupting a meeting because of a motion that could have been moved anytime. Madam Chair, this is disturbing. When we talk to people of the industry and sectors that fall under Canadian heritage and who we hear people saying that we have no credibility, we have become a joke because we are unable to complete any study. Madam Chair, I'm fed up. I've had enough of this, that we are not able to take our work seriously. The motion that was moved is not a bad motion, but why was it moved at the beginning of a meeting, whereas we had important witnesses? I'm not done, Madam Chair. I will conclude. We could have discussed that another time, and now people took advantage of it to make political statements. Now, at the end, the NDP comes up with another political statement to condemn a political leader, rightfully so or not. We had a study. We had to talk about C316 today. We've wasted 2 hours of our time. Madam Chair, I'm asking adjournment of this meeting.
Thank you, Martin. Mr.
Madame la Présidente, j'ai demandé le vote obligatoire. Merci.
Madam Chair, I moved adjournment of the meeting.
On vote?
We should vote to adjourn the meeting.
The vote is on the motion to adjourn the meeting. Mr. Coteau.
No.
Madame Latanzio.
No.
Monsieur Sanson.
No.
Madame Romanado.
No.
Monsieur Serry.
No.
Mr. Waugh.
Yes.
Ms. Thomas.
Yes.
Monsieur Gourde.
Oui.
Mr. Lawrence.
Oui.
Monsieur Champoux.
Oui.
Ms. Ashton.
No.
Yeas pour 5-5, nays contre 6-6.
The motion to adjourn is defeated. So now, do we have anybody else who wishes to speak on the amendment? Ms. Thomas? Yes? Yes, I have Ms. Thomas, and that's the only other person on the list.
Thank you. It looks like Mr. Gourde is also on the speaking list.
You?
Okay, thank you. Wow. So there's been a lot of talk that has come from the Liberal members, in particular Mr. Coteau, and then the NDP members, Ms. Ashton, talking about this motion as if it's this, I don't know, this motion that they're wanting to bring forward out of goodwill for the people. And yet, when they've spoken to it, the only thing that they've done is taken the opportunity to attack the leader of the Conservative Party, which in doing that, then...
Point of order.
Mr. Coteau, is that you?
Yeah, I think the member's misrepresenting me. I spoke for probably a good 10 minutes, and my point about the leader...
This is not a point of order. Madam Chair, this is not a point of order. And this is not a point of order. Give me the section.
I will
this is
decide
exactly what the block member was saying. This is a joke.
Not, Mr. Lawrence. But I have to listen to it before I can tell you if it's a point of order or not. Will you allow me to listen to what the member is going to say? I'm sorry, Mr. Cotto, what were you going to say? I couldn't hear you.
Yeah, and I don't know who was speaking, but that was a very loud outburst. I could almost hear it here in Don Valley East without my my headset on. I was saying that what the member just said misrepresents me. I spoke about the issue about extreme right-wing hate in this country. I mentioned the member for probably 1 minute out of several. So I'd ask the member to withdraw what she just said because it's a misrepresentation of what I did.
Mr. Cotto, that's not a point of order, it's a point of privilege. But go ahead. You've asked for the member to withdraw what she said. I'm asking the member to withdraw so we can get on with the meeting.
I challenged the chair. There was nothing in there that was inappropriate. I challenged the chair.
I beg your pardon, Mr.
I
Lawrence.
challenged the chair. That you ordered the member to withdraw. Your decision is incorrect. I challenged the chair.
Mr. Cotto spoke to a point of privilege that he was misrepresented. And so go ahead and challenge the chair. Let's call a vote.
Madam Chair.
Call a vote to challenge the chair, please.
Okay.
Thank you.
I think we just need to clarify what was the...
She didn't order her. She asked her if she would like to apologize. That's all she said. No, she said I'm asking the member if she wants to.
Mr. Lawrence, I did not make a ruling on anything. I asked the member if she would withdraw her statement because Mr. Cotto asked her to, because he felt he was misrepresented. That's basically what's happening here. I have not made a ruling because I can't rule on that. Now, so Ms. Thomas, Mr. Cotto has asked that you withdraw the statement.
Madam Chair, by asking me to withdraw, you are then making a ruling. You're making a ruling in favor with Mr. Cotto.
I'm not making a ruling, Ms. Thomas, because people speak through the chair. I know you don't think they should, but Mr. Cotto made a statement. As a chair, I'm interpreting the statement that he made. I'm not ruling. I'm just asking if you wish not to withdraw, that's fine. I'm not compelling you to do anything.
So the chair is asking me to withdraw?
I'm saying that Mr. Cotto asked you to withdraw your statement. Will you?
No.
All right, fine. Mr. Cotto, Ms. Thomas does not wish to withdraw her statement.
Wow, you required my name for that.
No, yes, thank you. Mr. Cotto said that's fine. Now, Ms. Thomas, you were saying?
You are, oh my gosh, this is such a joke.
What?
But she called the chair a joke?
Yes, she did. She did. But it's okay. My skin is very thick.
Unbelievable.
No,
Go ahead, Ms. Thomas.
Madam Chair, I would call a point of order on you. What you just accused me of is incorrect. I did start out saying you, and I was going to make one statement. I withdrew and said, this is a joke. You just accused me, wrongly, of calling you a joke. Madam Chair, that is an inappropriate accusation that you just brought against me.
Ms. Thomas, you know what? I do not wish to debate you on issues like this because I think they are totally irrelevant and frivolous. So now, will you continue? You have the floor. Please go ahead.
Madam Chair, the point is this. There's a motion on the floor asking to study far-right extremism in Canada. And the Liberals and the NDP are choosing to move this motion because they simply desire to instigate a political fight. Both the Liberal and the NDP members have come forward and used this as an opportunity to attack the leader of the official opposition party. Those statements have been made loud and clear. Now, this amendment that has been brought forward by Ms. Ashton from the NDP makes it abundantly clear that this motion is not really about having a better understanding or gaining a better understanding as to what is going on in Canada with regard to extremism and its impact on people. The people who have elected us to represent them. That is not what this motion is about. Instead, Ms. Ashton, through her amendment, is making it abundantly clear that the desire is simply to attack the leader of the official opposition. That would be the intent of this motion, to go after him because he stopped on the side of the road and had a conversation with someone. And then it was learned that that individual comes from a group that has said some pretty disgusting things. And of course we don't stand with those things. But for Ms. Ashton to turn this motion into that type of game is exactly what my Bloc colleague has said. It turns this committee into a joke where we can score cheap political points by just throwing these accusations against one another, in this case against Conservatives, for what? For what? For a quick tweet that she just put out a few minutes ago? Congratulations. Something to be proud of. Like, this is an individual who ran for leadership for the NDP, for crying out loud.
Ms. Thomas? Yes, Ms. Ashton?
Thank you, Ms. Thomas, for sharing my life story. I look forward to hearing more. I just want to say I appreciate you questioning my motive. Well, frankly, everybody's motives. I do think it's very serious that your leader met with people that support Diagolon. I think that has an impact on Canadians who are targeted by the far right. And that's what this study is exactly about. I'd prefer if my motives stood for themselves based on the words that I shared earlier, and rather than your analysis and, frankly, your dismissal of how dangerous associating with supporters
This
of
is definitely not a
is.
point of order. This is debate.
Go ahead, Ms. Thomas.
So to turn this into cheap political gamesmanship is absolutely inappropriate. It's disgusting. It's a waste of committee resources. To the Bloc member's point, it turns this committee into a joke. I mean, for all of the reasons that I just listed, there's just no way that I could support the amendment that has been brought forward by the member, and I would move a motion to adjourn committee.
I will call the question on adjourning, although it is now actually the exact time that the meeting is meant to end, as told by the clerk. So I will actually suspend the meeting. Because Thank you.